Thank you very much. Good afternoon, ladies and gentlemen. First of all, thank you for the invitation. I am delighted to be here. It is also an honor to represent my law firm in this beautiful event. It's our first time here, and first of all, let me take 1 minute of our attention to introduce who we are. Which one? This one? Okay, just really quick. We are a full-service law firm in Recife. It's our headquarters, but we have branches in many capitals of Brazil, and we work in all nationwide. So we have specialty in all the fields that companies need. So except for criminal law, we are able to provide service to companies in general. And we have around 1,500 clients, including multinationals as those. Okay, entering the subject that Alex proposed to us, it is a tough question to answer. Regarding the Brazilian labor law, it's a very complicated law with thousands of rules spread over constitution, federal laws, decrees. And, well, the idea of the new labor law is to simplify labor relations in general. First of all, it's important to introduce a basic concept. Brazil has a very comprehensive constitution, and it provides more or less 40 labor rights, individuals and collective labor rights. And examples such as unemployment benefit, minimum wage, irreducibility of salary, etc. It is a very, very comprehensive constitution. Sorry. It's important to say that these constitutional rights are set in stone, so it can't be an object of amendment or deletion. And in addition, as I said, to these constitutional labor rights, there are thousands of rules regarding all aspects of labor relations. And in complementary of law, companies and unions can sign collective agreements with the force of law according to our Constitution. So in this normative labyrinth, in the event of conflict between labor standards, which norm should prevail? Okay, and there is a concept in Brazil that should prevail the most favorable standard to the employees. But the question is, what is a most favorable standard in a concrete case? You know, it's a very, very uncertain concept, and it depends on, well, the case. You know, it's really difficult to predict which norm will prevail in case of conflict. And beside of this normative labyrinth, Brazil has a specialized labor justice system. And, well, I think the justice system, labor justice system of Brazil is the main character of our labor reform, because in the recent past, after the Worker Party took the office, many judges were nominated to the Superior Labor Court with a very left-wing position. and the labor court has advanced in amplifying the labor standard, and well, it led to a lot of complaints from companies and society in general regarding the instability and the unpredictability of the labor justice decisions. However, legal security is connected to stability, transparency, predictability. Yeah, predictability, I believe, it's the most important aspect of legal security. It's important to know the rules and to predict what will happen during the contract. And permanence of norms and relations. Okay, this is more or less the concept of legal security. And regarding this, the main objectives of Federal Law 13467, which is the Brazilian labor reform, are to reduce formal labor costs, not in terms of wages and salary necessarily, but in terms of the cost to maintain an employment contract in Brazil, which is very high. It's said that the amount you pay to the employee as a wage is exactly the amount you pay to the government to keep that employment contract. And it's too expensive to spend the double of the cost of the work properly in tax obligations, social obligations. And the idea of the Federal Law 13467 is to ease the situation, to provide flexible contracts, flexible workforce arrangements, working hour arrangements, dismissal mechanisms, and to eliminate also the federal funding of unions, and to limit, as I said, the instability in legal interpretation by the labor justice. These are the declared objectives of the new labor law in Brazil. In summary, the changes are, and it's important to say, it's not into force. It will enter into force in November 11th. So we still have an old law, but the new law is just on the way. So in terms of, we divided the presentation in three aspects of the labor reform. Regarding labor contracts, there is a current and general rule which remains. It doesn't change. And the rule is that the private labor contracts cannot contradict, cannot modify labor norms and forms. Okay, so the freedom of will regarding the labor relations in Brazil, well, almost doesn't exist. The labor reform is providing an exception now. It's a paradigm shift. It is a real game changer because, well, it's a really strong change. And it creates, the labor reform creates a type of worker who can negotiate directly with the employer conditions and obligations regarding the contract over the law. You see? And there are two characters, which is a graduate employee. It needs to be a graduate employee, and it needs to be a high salary employee. Now, it's the employee must earns more than 11,062 reais. It's our currency. It's about 2,500 euros. The other break with tradition is that now to these high employees, high salary employees and graduate employees, it is possible, it will be possible to sign a commitment to arbitration on the initiative of the employees or through mutual agreement. It is also a break with tradition, because now it's impossible to submit any litigation to arbitration concerning the labor relations in Brazil. Another change regarding contracts are the examples, are the new flexible contracts it brings. And there are 3 examples of new contracts, new flexible contracts. Flexible hour, 0-hour contract, work off in the premises, and revise part-time jobs. We already have a part-time job contract in Brazil. Okay, thank you. But it was revised. Furthermore, the reform provides permission for unrestricted outsourcing, including of the company's core activities. Now it's not possible to do outsourcing in core activities, only with secondary activities, and the labor reform changed it. And finishing the labor contract aspects, flexible arrangements of working hours and overtime compensation, which can be negotiated directly between employee and employer. Okay, the current rule requires union participation in the collective bargaining to establish compensation or rules regarding to working hours. The other aspect of the reform we detached are related to the unions. It establishes that collective bargaining agreement will prevail over the law, except, of course, with respect to the constitutional labor rights we said before. And the other change regarding collective agreement is that now, it will be November 11th, the collective labor agreement, which is an agreement signed between company and union, will always prevail over the collective labor convention, which is an employers association and union agreement. Okay, the idea, I repeat, is to stabilize labor relations and make possible agreements directly negotiated between employees and employers. Another change, I saw that Mr. Macron reform also contains more or less the same thing. In companies with over 200 employees, it's guaranteed at election to form a commission to negotiate directly with employer, but without the power to enforce labor agreements. Okay, well, I see it as a step to the unions, and the idea of the labor reform is to provide more power to the employees to negotiate directly, getting the union out of the process. Okay, to finish it, federal labor justice system, which is we call it a jabuticaba. Jabuticaba is a fruit which only exists in Brazil, so we have a federal labor justice system specialized, but historically we had a lot of controversy on critical issues, especially regarding shareholder liability and criteria for disregarding the corporate entity. Okay, it's because for the labor justice, the simple default on payment during the judgment execution is enough to disregard the corporate entity. So the current Brazilian labor reform creates a strict procedure to the disregard of the corporate entity, and this procedure guarantees the right of defense and appeal to the shareholder without any act in the judgment execution. First, the idea of the labor reform is to finish firstly, the discussion between the liability of the shareholder to advance in the execution. Brazilian labor reform also established objective criteria regarding liability, especially in the event of corporate succession. So, in conclusion, to finish and to answer to the question of the presentation, we can say that since the enactment of our Constitution, Brazil has been carrying out flexibilization of labor standards toward deregulation. It's a trend we can see historically since the enactment of the Constitution. Despite the Worker Party in power, it kept deregulation, the labor relation, and of course there is still that labyrinth to unravel, but the current labor reform eases or intend to ease the maze by establishing, as I said, flexible contracts and working hour arrangements, and the idea is to decrease informality. So, the labor reform in Brazil intends to bring greater legal security, not only for foreign investors, but also to foreign investors, with respect to the stability of the collective agreements, okay, and especially to the predictability of the rules concerning the liability of companies and shareholders. Okay, thank you.